All right, so we're still on deciding cases. The court's consideration of a case is based on the abstracts, the record, and the briefs. No evidence is heard. Attorneys are permitted to make oral arguments. All statements and justices' questions are tape recorded. Justices meet and discuss and vote on cases in conference held each Wednesday and Friday throughout the term. Conferences are strictly private. Decisions. When the court has reached a decision, its opinion is written. The opinion contains the court's ruling on the issue or issues presented, the reasons for its decision, the rules of law that apply, and other information. In many cases, the decision of the lower court is affirmed or they agree with the lower court. If the court feels that a reversible error was committed during the trial or that the jury was instructed improperly, the decision will be reversed. Sometimes the case will be remanded, sent back to the lower court that had originally heard the case for a new trial or other proceeding. The court's written opinion sometimes is unsigned. This is called an opinion per curiam by the court. Typically, the court's opinion will be signed by all the justices who agree with it. Usually, when in the majority, the Chief Justice will write the opinion. Whenever the Chief Justice is in the minority, the senior justice on the majority side decides who will write the opinion. When all justices unanimously agree on an opinion, the opinion is written for the entire court, all the justices, and can be deemed a unanimous opinion. When there is not a unanimous opinion, a majority opinion is written outlining the views of the majority of justices involved in the particular case. A concurring opinion results when a justice agrees with the majority, but for different reasons. In other unanimous opinions, one or more dissenting opinions are written by those justices who do not agree with the majority. The dissenting opinion is important because it often forms the basis of the arguments used years later that cause the court to reverse the previous decision and establish a new precedent. Shortly after the opinion is written, the Supreme Court announces its decision from the bench. The opinion is published in the U.S. Reports, which is the official printed record of the court's decision. We now need to discuss the final theme, which is the power of the federal judiciary, or the power to make public policy. The federal courts have the power to make policy, specifically the Supreme Court, by interpretation of the constitutional law, by extending the reach of existing law, by designing remedies that involve judges acting in administrative or legal ways. We've said previously that 160 laws have been declared unconstitutional. The number of prior cases overturned, is approximately 260 since 1810. They have not followed what we call stare decisis or precedent decision, the decision that stands. The extent to which judges will handle cases once left to the legislature are called political questions. A political question is one that the Supreme Court declares should be decided by the elected branches of government, the executive, the legislative, or those two branches together. Typically, if a political question is involved, the Supreme Court often will exercise judicial restraint and refuse to rule on the matter. Views of judicial activism. Judicial activism and judicial restraint are what judicial scholars like to characterize different judges and justices as being. The doctrine of judicial activism rests on the conviction that the federal judiciary should take an active role in using its powers to check the activities of Congress, state legislatures, and administrative agencies when those government bodies exceed their authority. One of the Supreme Court's most activist eras was the period from 1953 to 1969, when the court was headed by Chief Justice Earl Warren. The Warren Court propelled the civil rights movement forward by holding, among other things, that laws permitting racial segregation violated the Equal Protection Clause. The doctrine of judicial restraint rests on the assumption that the courts should defer to the decisions made by the legislature and executive branches because members of Congress and the President are elected by the people, whereas members of the federal judiciary are not. Because administrative agency personnel normally have more expertise than the courts do in the areas regulated by the agencies, the courts likewise should defer to agency rules and decisions. In other words, the court should not thwart the implementation of legislative acts and agency rules unless they are clearly unconstitutional. Judicial activism is sometimes linked with liberalism and judicial restraint with conservatism. During the Rehnquist court, he was the 16th Chief Justice, placed in that position in 1986, after he had been an Associate Justice for 15 years, he was more of a conservative anchor to the Supreme Court. It seemed to observers that the court would become more conservative when Rehnquist became the Chief Justice, and this did happen. Newly appointed Chief Justice John Roberts, who replaced Rehnquist, is more of a moderate conservative. Newly appointed Justice Samuel Alito, replacing Sandra Day O'Connor, is regarded as a reliable conservative, but has been known to be an unpredictable and fiercely independent justice who isn't afraid to hand down unpopular rulings, but we haven't seen that so far. The ideological alignment for Justice Sonia Sotomayor and Justice Elena Kagan, who were appointed by the Obama administration, they lean more to the liberal side of the spectrum. Since the mid-1990s, the court has issued numerous conservative rulings. Several of these rulings reflect a conservative approach to constitutional law with respect to states' rights and other federal issues. For example, in 1995, the court curbed for the first time in 60 years the national government's constitutional power under the Commerce Clause to regulate intra-state activities. In view of the court's support for states' rights, many scholars were surprised when the court involved itself in the dispute over the manual recounting of the Florida votes after the 2000 elections, which should have been viewed as a political question. In regards to civil rights issues, the Rehnquist Court's generally conservative, strict interpretation of the Constitution has had mixed results. It'll be interesting to see the decision on the affirmative action case, Austin versus Texas, and the decision on the Voting Rights Act when it comes through. Views of judicial activism. Well, supporters of judicial activism believe that the court should correct injustices when other branches or state governments refuse to do so. They also believe that the courts are the last resort for those without the power or influence to gain new laws. The critics of judicial activism state that judges lack expertise in designing and managing complex institutions, and that initiative or laws require balancing policy priorities and allocating public revenues. They also claim because the judges are not elected, they are not accountable. Possible reasons for judicial activism are we're in a very adversarial culture, where emphasizing individual rights and suspicion of government power is paramount. And it's easier to get standing in the courts than it is to get legislation passed. Laws in the Constitution are filled with vague language, which increase the court's opportunities to design remedies. The federal government is increasingly on the defensive in court cases, because the laws induce court challenges. That occurs. The attitudes of federal judges affect their decisions when the law gives them latitude. Okay. So what checks the courts? Our judicial system is probably the most independent in the world, but the courts do not have absolute independence, for they are part of the political process. Political checks limit the extent to which courts can exercise judicial review and engage in activist policy. These checks are exercised by the executive branch, the legislature, the public, and finally the judiciary themselves. Executive checks. The Supreme Court simply does not have any enforcement powers, and whether a decision will be implemented depends on the cooperation of the other two branches of government. Rarely will a president refuse to enforce a Supreme Court decision. To make such an action could mean a significant loss of public support because of the Supreme Court's stature in the eyes of the nation. More commonly, presidents exercise influence over the judiciary by appointing new judges and justices at federal judicial seats become vacant. The Solicitor General plays a significant role, and the person holding this office is a presidential appointee. Executives at the state level also may refuse to implement court decisions with which they disagree. A notable example of such a refusal occurred in Arkansas after the Supreme Court ordered schools to desegregate in 1955. Governor Faubus refused to cooperate with the decision and used the state's National Guard to block the integration of Central High School in Little Rock. President Eisenhower had to federalize the Arkansas National Guard and send federal troops, the 101st Airborne, to Little Rock to quell the violence that had erupted. Legislative checks. Courts may make rulings, but often the legislatures at local, state, and federal levels are required to appropriate funds to carry out the court's rulings. When such funds are not appropriated, the court that made the ruling, in effect, has been checked. Court rulings can be overturned by constitutional amendments at both the federal and state levels. Many of the amendments to the U.S. Constitution, such as 14, 15, and 26, check the court's ability to allow discrimination. For example, proposed constitutional amendments that were created by a desire to reverse courts' decisions on school prayer and abortion have failed, at least up to this point. We'll see with the new Arkansas law. Congress or a state legislature can rewrite or amend old laws or enact new ones to overturn a court's ruling if the legislature concludes that the court is interpreting laws or legislative intentions erroneously. Public opinion plays a significant role in shaping government policy. Persons affected by the Supreme Court decision that is noticeably at odds with their views may simply ignore it. Prayers were banned in public schools in 1962, yet it is widely known that the ban was and still is ignored in many southern districts. What can the court do in this situation? Unless someone complains about the prayers and initiates a lawsuit, the courts can do nothing. The public can also pressure state and local government officials to refuse to enforce a certain decision. The courts themselves necessarily are influenced by public opinion to some extent. Their attitudes are influenced by social trends, such as the attitudes and beliefs of all persons are. Courts generally tend to avoid issuing decisions that they know will be noticeably at odds with public opinion. The doctrine of stare decisis acts as a restraint because it obligates the courts, including the Supreme Court, to follow established precedents when deciding cases. Only rarely will they overrule a precedent. In the 21st century, the judiciary remains one of the most active and important institutions in American political life, particularly at the federal level. Judicial decision-making through the years has affected the way all of us live and work. As the ultimate decision-maker on constitutional issues, the Supreme Court will continue to play a significant policy-making role in American government. Since the 1980s, there has been a trend toward noticeably more conservative federal judiciary. Given the possible retirement of some of the Supreme Court justices in the next few years, the composition of the court may change. A number of key constitutional issues will continue to be brought before the federal judiciary. These include affirmative action. We see that now in Austin versus Fisher. Congressional redistricting to maximize minimum minority representation. Indecent speech on the internet. Privacy rights, and a variety of other civil rights issues, as well as questions involving states' rights. The work of the judiciary in this sense will always remain unfinished. There's also been no attempts to curb judicial activism. Activism has increased because the government does more, and courts must interpret the laws. Activist ethos of judges is now more widely accepted.